Okay. Good morning, everyone. Thanks for hopping on our webinar. We are talking today about meal periods and how to ensure compliance in your hospitality business. We are joined by our good friends at Jackson Lewis, Adam Gross and Cassandra Facano. They're going to lead you through the presentation. As a reminder, I'm Sarah Higgins. I'm the Member Education and Events Director with this association. Just a few housekeeping items before we get started. The presentation is being recorded and the recording will be available in our webinar archive, and you can access that at any time to view any of our previous webinars by logging in at NYS.org, and that's a benefit that is available to members. So if you are interested in learning more about our webinar archive and all of our other member benefits here at the Restaurant Association, you can send an email to info@NYS.org. We're always happy to help you. We assume there will be questions as always. You can enter those into the Q&A box, and we will get to those at the end of the presentation after the material has been delivered. And I will turn it over to Adam to get started. Adam, thanks so much for joining us.
Thank you so much, Sarah. It's good to be here with everyone. We were excited to see that there was so much interest in meal breaks, and that is what we are going to be talking about today, the ins and outs of meal break compliance in the hospitality industry. And one of the frustrations about this topic for many of the restaurants with whom Cassandra and I work is that there is really nothing special or nothing different about the requirements in this industry versus other industries, which, as we will talk about, and I'm sure as many of you have experienced, is relatively impractical because it is a very different industry. Your industry is a very different one than someone working in an office all day. So we will talk about some of those impracticalities and how various operators are dealing with them as we move forward. So Cassandra and I are, we work at Jackson Lewis. Jackson Lewis is we are a national law firm, and we are exclusively a workplace law firm. So we represent only employers across a broad spectrum of industries all over the country in connection with absolutely anything that involves their employees, including, and we have a large industry group that's focused on this specific industry, the hospitality industry, with which Cassandra and I do much of our work. And we are always happy to help and always proud to partner with the State Restaurant Association to help educate its members and to hopefully pass along some valuable information about very complicated compliance schemes here that we deal with in New York. So with that, Cass, you can keep going. So we will, as I said, we have a bunch of industry groups. We have a diverse background of practice groups across a broad spectrum of areas. And as I said, anything involving employees, we have boots on the ground across the country and are ready and able to assist. So with that, here's our agenda for today's session. We're going to leave plenty of time at the end for questions because we expect that there will be some, given the lack of specificity in the regulations here. And so with that, we're going to jump right in. So we're going to go through the basic requirements of meal periods, what the law actually says, which is not much. We'll go through a couple of exceptions to the law, a couple of the different scenarios of paid versus unpaid lunches and how that changed things, the credits that you're allowed to take for a meal break, but only under very specific circumstances, the enforcement, which is often something that we find clients are sometimes a little bit confused about what the enforcement is of these meal break laws. And then we'll also talk about some best practices with respect to timekeeping and related record keeping to try to minimize risk associated with compliance with these regulations. And so with that, I'm going to turn it over to Cassandra, who's going to kick us off.
Okay, so like Adam said, we're going to start with the basic requirements for meal periods under the New York labor law. Just a reminder that meal periods are not required under federal law. The way that the New York labor law is worded is particularly not practical, as Adam already mentioned, but we're going to go through what exactly it says. So if you have an employee who is working 6 or more hours on a given shift, and that shift starts at 11 a.m. and ends after 2 p.m., you are required to provide a 30-minute unpaid meal break period. And then to the extent that that employee works beyond 2 p.m., if they're working past 7 p.m., they must be allowed an additional 20-minute meal period. The wording of this is very impractical only because we recognize that, employees are not necessarily starting their shift before 11 a.m. or after 2 p.m. People are coming in. I'm sure everybody is familiar, the evening shifts might not start until 4 p.m. So with that, just practical tips to keep in mind is, to the extent that someone is working 6 hours and a meal period needs to be provided, as a best practice, the meal period is supposed to be provided at the midway point. We recognize that that's, again, not always practical. To the extent employees all start the shift at the same time, we can't have all employees go out on break at the same time. Or, sometimes the mid period might be the busiest time of the restaurant. So to the extent that that's not practical, we recommend that you do your best to do the midway point for any breaks, but to the extent that you can't, it's fine to stagger meal periods and to do what works best for you, but just keeping in mind that it should be somewhat in between the mid period to the extent you can. So what is a meal period and what counts as a bona fide meal period under the law? To be a meal period, generally it must be 30 minutes or longer. Practical note is that it can be less than 30 minutes without DOL approval, so long as it's not a hardship to employees. It must also be, the employee must also be relieved of all of their duties during the meal period break. That means no interruptions, no, can you just do this really quickly during your break? It's completely uninterrupted, completely relieved of all duties. And then the third requirement is that the employee must be permitted to, it's not necessarily required that the employee be allowed to leave entirely, but they should be permitted to leave the workspace that they're primarily stationed at. And the reason for that is, they're not going to be doing off the clock work. They're not going to be working during their meal period if they're not stationed at their workstation.
So just to mention, so to follow up on one thing that Cassandra just said, in order for it to count as a compliant meal period, it needs to be a completely uninterrupted break of 30 minutes. So that means that, for example, if people are eating during a pre-shift meeting, that's not going to count because the pre-shift meeting constitutes work. If people are eating for 15 minutes, there's an interruption by a manager for 5 minutes to talk about something related to service or what's going on in the restaurant that evening, and then they eat for another 15 minutes, that does not constitute a compliant meal break because you have a 15-minute period followed by a 5-minute working period followed by another 15 minutes. People had in total 30 minutes of time to eat, but there was not an uninterrupted break of 30 minutes because there was an interrupted break. So just to keep in mind, in order for the meal break to be considered lawful, you have to provide a completely uninterrupted break. And we will talk in a bit about some of the issues with respect to compensability of the breaks, and that can be a big factor as well if you're not paying people during their meal breaks.
So another common question that Adam and I see is, if an employee wants to leave their shift early, can they exchange that? Can they say, I don't want the meal period, I just want to leave the shift early for the same amount of time? If an employee is asking for this on a long-term regular basis, the Department of Labor is going to say, no, that's not allowed. An employee cannot, generally as a rule of thumb, waive their right to a meal period, even in exchange for leaving early. If it's on an occasional basis and it's due to the employee need, one-offs, I have to, whatever the reason is, that is okay. But as a rule of thumb, if it's going to be on a regular basis, generally not allowed. So
Okay.
Are there exceptions?
So are there exceptions to the meal break requirements? The answer is yes, but they're very minimal and most of them will not apply except in very limited circumstances. So there is an exception for a meal break when you have a one employee shift. So you have a very small operation, it's staffed by only one person at a time. the idea is that you shouldn't have to necessarily close down your operation for 30 minutes to ensure that the individual employee gets a meal break. In that limited circumstance, you can forego the meal break, but it has to be done on a voluntary basis. So if the employee doesn't want to forego the meal break, then you would still have to comply with it. The acknowledgement, if you're going to, if the employee agrees to forego the meal break, should be in writing. And the time that they're working would obviously have to be paid, because you don't get the credit for an unpaid meal break. They're working the entire time. There is no break, so the entire shift would have to be paid. You can go to the next slide. Thank you. So, compensability of meal periods. And I would say that among the topics that we get questions on as it relates to meal breaks, the compensability of meal periods is a big one. So meal periods that constitute complete uninterrupted breaks from work of at least 20 minutes in duration do not have to be, or more than 20 minutes in duration, do not have to be paid. Meaning that if someone has a 30-minute meal break that is a complete break from work without interruption, you do not have to pay that employee for those 30 minutes. However, if it is not a completely uninterrupted break, in the example that I gave 2 minutes ago about 15 minutes of uninterrupted eating, 5 minutes of work, another 15 minutes of uninterrupted eating, those would only be considered 2 15-minute breaks, not a 30-minute break. Breaks between 5 and 20 minutes are compensable, which means that by law, they have to be paid. So if someone does not have a break of at least more than 20 minutes, it has to be paid. That becomes sometimes tricky when you are processing payroll. A lot of operators or a lot of restaurants are processing payroll directly from their timekeeping system, their POS system. And so you're just paying people to the minute of what they were paid. In practice, that is the right way to do things. That is the right way to go about doing things. But you just have to make sure that you have a check to make sure that you're not at any point in time deducting for time that is less than a 21-minute break. So if it's between 5 and 20 minutes, it needs to be paid. And so you have to have some sort of system, an administrative system, to check to make sure that you're not at any point in time deducting from employees' pay for a break that's less than 21 minutes to ensure that you don't have an issue. So whenever the labor law requires meal periods, you have a choice. So you do not have to provide food to employees in your industry. It's often, it's relatively common that meals are provided to employees because that's the business that you are in. But you do not have to, by law, provide meals to employees or provide food for employees to eat during their meal breaks. But you do have to allow the employees to bring their own food to the work site in the event that they want to do so. So you can either provide food for employees. We'll talk in a moment about whether you can deduct from employees' pay as a result of providing them food, but you have to allow employees to bring their own food should they wish to do so.
Okay, so if you are furnishing a meal and you want to take a credit or you want to take a deduction for it, we've laid out all of the different credits that you can take. New York City and downstate have the same limits, and then the remainder of downstate is noted below. And we just did it for the next couple of years, just so you have the numbers in front of you. But there are certain requirements for you to take the credit for the meals, as Adam just said. So if you are taking a meal credit, you can only take a meal credit if you're furnishing a meal that is compliant with New York regulations. I'm just going to move this because it seems to be blocking some of the text. So if you're taking a meal credit, the meal that you're providing needs to have quote unquote adequate portions, which is not defined under the law, a variety of different foods. There needs to be at least one type of food from each of the following groups. So fruits or vegetables, grains or potatoes. You can see on the list, at least one from each of these to take the credit.
It seems ridiculous that this would actually be codified by law, but this is directly from what we call the hospitality wage order, which is the group of regulations that governs compliance with all sorts of wage and hour requirements for this specific industry. So the hospitality wage order is specific to the hospitality industry in New York. This comes directly from that wage order. So in order to, if you are going to charge employees for a meal, you have to ensure a number of different things. You have to ensure, number one, that they have an adequate opportunity to eat the meal. So they have to get the break and have an opportunity to actually eat it. And the meal itself, the components of the meal have to meet the requirements of the wage order as shown on this slide. And as ridiculous as it seems, we often see litigation in which the focus of the litigation, at least in part, is on the idea that employees claim that that the restaurant unlawfully deducted a meal credit from the employee's pay, and one of those reasons could be that the substance of the meal itself did not meet each of these components.
And also, just to add to that, is under the regulations, the hospitality wage order, meals are deemed furnished by an employer when they're made available to the employee during their reasonable meal periods and are customarily eaten by that employee. So the employee doesn't necessarily need to eat every meal provided to it, so long as, customarily, they're regularly, at least, 3 out of 4 times eating the meal that's furnished, that would be sufficient.
And that they have an opportunity that they're provided an opportunity to actually eat the meal.
Exactly.
On the last slide, you saw the rates for the various the credits, and they vary depending upon where you are in the state, and they go up each year for the next few years. It has always been backwards to me that you're actually allowed as a restaurant to deduct a much larger credit for non-front of house tipped employees than you are for the tipped employees, who often are making much more money by virtue of the fact that they're receiving tips. So you can see that the difference is sometimes almost as much as $2 between the meal credit you're allowed to take for a dishwasher, for example, which would be the other category. So you have the other category, the service category, which is tipped employees but not food service workers. So for example, delivery folks, maybe bathroom attendants, folks like coat check attendants. And then you have the food service workers, which are your traditional front of house employees, who are often making the most money amongst the non-managerial employees at the restaurant by virtue of receiving tips. Yet you're only allowed to deduct a smaller amount for a meal for them than you are for the back of house folks. Okay, so limits on permissible credits for meals. So if you are taking a credit, if you are deducting from an employee's pay by virtue of providing a meal for the employee, you're not allowed to take more than 1 meal credit for any employee working less than 5 hours on any day. So typically, if someone's working fewer than 5 hours, they only are being accounted for 1 meal, so you wouldn't be deducting more than 1 meal anyway. But you should note that you are not permitted to deduct more than 1 meal for anyone working fewer than 5 hours. You also are not allowed to take a credit of more than 2 meals for any employee on any given day. So even if you provide 3 family meals during the course of you're a continuous service establishment, you provide 3 different family meals to employees throughout the day. 1 employee is working throughout the day. Typically, you're not allowed to take a credit for more than 2 meals for any 1 employee on a given day. There are the circumstances in which someone might be asked to work through 3 meal periods tends to be relatively rare, but everyone should understand that limitation. Okay, this is one of the biggest questions, maybe the most important question we deal with when it comes to meal breaks. And there's often a misconception amongst operators in the industry. How are violations of these regulations, the law on meal breaks that we reviewed at the beginning of this presentation, how are they enforced? The answer is that there is technically no private right of action, meaning that an employee who believes that they should have been given a meal break and they were not, or that they should have been given a meal break at a specific time during their shift and they were not, or that they were not given an uninterrupted meal break of at least 30 minutes, does not have the ability to bring that claim in court. It is not a claim that an employee can go get a lawyer and sue a restaurant for failure to provide a meal break. It is enforced by the Department of Labor. So an employee could go to the Department of Labor and make a complaint, and you could be, you could be the subject of an investigation by the Department of Labor, but there is no private right of action for a violation of the meal regulations. With that said, we want to be very, very clear. That does not mean that enforcement is not, that compliance with these regulations is not important. And oftentimes it's because although there is no private right of action directly associated with failure to provide a meal break, there are ancillary claims that are related to the meal period in one way or another, that absolutely are subject to a private right of action and private enforcement. So one of the things, for those of you who have had the misfortune, and hopefully it's not many of you who are listening, but for those of you who have had the misfortune of being involved in a dispute with an employee over their wages, you know that once a employee seeks an external solution for a problem, meaning that they don't come to the restaurant to help fix whatever it is that they believe is aggrieving them, they go externally to a lawyer, for example, that the lawyer is going to poke around and try to find something that sticks. And so oftentimes if an employee who may not have an understanding as to whether there's a private right of action with respect to a specific claim, if an employee, meal breaks are very personal to employees. A lot of employees feel very strongly about their meal breaks. If they are not getting meal breaks, and employees are perfectly capable of Googling the requirements of the meal periods just like anybody else is, if they are not getting a meal break in accordance with what they believe they are entitled to, it's often one of the things that triggers an employee going to find an external solution. And even if the meal break doesn't become the impetus for a claim, if you have a lawyer poking around and looking at the employee's pay stubs and investigating in an effort to find something that might stick, you're much more likely to have a problem. So that's number one. Number two, if an employee goes to the Department of Labor, we'll talk about what the fines are for a violation in a moment. But the Department of Labor typically won't limit its investigation just to a meal period investigation. It might look to expand the scope of the investigation to ensure that you're providing employees with the correct amount of pay, providing spread of hours, paying for all time work, providing adequate notice of the tip credit, et cetera. So it is oftentimes an issue that even if itself can't be enforced privately, it can lead to a much larger problem.
Yes, to add to that, I was actually just looking at the Department of Labor's website for employees to submit complaints, and it definitely inquires into, far-reaching things outside of the meal credit. So, there are examples of a day in, one day in seven, a day of rest, for example. Are people being paid PTO? It's very granular as to the details that need to be provided in a specific complaint, which definitely, as Adam already said, has the potential to impact you, far beyond just the meal periods. And with that, it's not without violation, it's not without a penalty. There's civil monetary penalties that can be enforced by the Department of Labor. And it can also just bring you as an organization on the DOL's, radar, and their investigation can be far reaching. They can ask for, for example, all time records, all payroll records for the applicable period. So just to put on your radar, and not to scare anybody, but there are civil monetary penalties that can be assessed if you are found to be in violation. So first-time violation can be up to $1,000, second can be up to $2,000, and then third or subsequent violations can be as much as $3,000. And to the extent you have, numerous employees, this can add up quickly. So just something to keep in mind.
And anyone who's had the displeasure of dealing with a complaint from an employee to the Department of Labor knows that the complaint may be about a meal period violation, and then out of the blue, seemingly to you, you have no knowledge that it's coming. You get a literal knock on your door from a Department of Labor investigator demanding 3 years of pay, full pay records for every employee that you've had on your payroll for 3 years, 3 years of time records, tip records throughout the entire period, various tax records, bank statements. They have broad authority under the law to request documentation to ensure compliance with the laws that it's it's required to enforce. And so you don't want to be in the situation of having a meal break complaint or lack of compliance with the meal requirements leading to that sort of burdensome response.
So best practices for timekeeping in relation to meal periods. So under both state and federal law, you're not required to actually keep the time that people spend on breaks. However, you are required to keep records of all hours worked. So what we often recommend is that you have employees contemporaneously punch in and out when they're working. So if they start at 8, they punch in at 8. If they take a break at 12, they punch out for that break and punch back in when they return to work. Obviously, this isn't always feasible for every employer to the extent you have, a numerous workforce and there's a lot of employees. It's not often practical to have 100 employees clock in and out at one timekeeping clock. So to the extent it's not practical, it's fine. We just recommend that if you're taking auto deductions or, if your system is just allowing for that meal period, just to have an airtight system for employees to report any discrepancies. So to the extent we are deducting, 30 minutes for a meal period, we need to ensure that that's at those 30 minutes, as Adam already said, are uninterrupted. To the extent that they're not, the employee needs to have a mechanism to go to you and report that inaccuracy and then get paid for that time to the extent that it needs to be paid. So we recommend having, training as to timekeeping systems. To the extent you want employees to clock in and out, make sure that they know how to do so and when to do so. And then to the extent we're not doing the auto deducts or anything like that, make sure that you have correction forms or that employees know who they can go to report any inaccuracies and to make sure that all time worked is actually reported.
And Cassandra mentioned the sign-offs. The reason that that's important is that it is not a good position to be in where you don't have time records that match up with the hours that people work, and we're taking the position. We have a manager who's systematically making changes to time records to account for an alleged unpaid meal break, but without any indication that the employee signed off on the changes to those time records. It's going to make it look like the restaurant is manipulating the records intentionally to try to get out of paying perhaps overtime for employees for working through their lunch. So if we're going to be making changes to time records or we don't have a time record, it's very important to have some other form of documentation to demonstrate that the employee signed off on this change, that it's an accurate change, and that it's reflected accurately in our records.
So kind of just adding on to what Adam said, why is accurate timekeeping reporting? In addition to what he already said, failure to do so can be expensive to the extent someone claims that they were working through meal period. We see this often. To the extent someone, claims that they were working through their meal periods, the statute of limitations for New York labor law claims for off the clock can date back to 6 years. So, there's definitely exposure in these kinds of claims. And in addition to that, it's the law that we're required to record all hours worked, as I already said. So just making sure that if an employee is working, that time is being recorded, and to the extent that they're not, that, that's fine. We'll leave that to the side, but make sure that if they are working, we have a record of it and that we're paying it appropriately.
So automatic deductions for meal breaks. So Cassandra mentioned this at one point a couple of minutes ago. We see a lot of operators who do not have, because it's either administratively impractical or employees are incapable of remembering to do so. We have a lot of experience dealing with restaurant operators who do not want to pay employees for their meal breaks, but also do not think it's practical to enforce employees clocking in or clocking out when they begin their break and clocking back in at the end of their break. And so what they do instead is they have what we would call an auto deduct policy, meaning that everyone gets to take a half-hour break a day, and we are just going to assume as a business that employees are taking that break. So we're going to automatically deduct. So if someone clocks in for work at 10 a.m. and then clocks out from their shift at 4 p.m., that's a 6 hour, if my math is correct, that's a 6 hour time period. but we're only going to pay them for 5.5 hours because it's assumed that 30 minutes within that 6-hour shift was an uninterrupted meal break. It's technically not unlawful, as Cassandra mentioned, to have an auto deduct policy, but I will just tell you, as a best practice, auto deduct policies are a very, very common issue in litigation. They breed litigation because it gives the employee. We are now in a position of having to prove prove that an employee took a break, an uninterrupted break for 30 minutes without any documentation to be able to demonstrate that the employee did so. And so what it creates is a scenario where an employee says, I regularly, our dinner shift or our lunch, the lunch rush or the dinner rush is always so busy. There's no way I ever took, a full 30-minute break. Most of the time I didn't take any break at all. Sometimes maybe I took, 10 to 15 minutes, but never anywhere close to 30 minutes. And that shifts the burden on us, who we do not have a time record to demonstrate that they took the break, but on the restaurant to be able to prove that that employee actually took a break when the employee is now claiming that they didn't. And as Cassandra said, we're talking about a 6-year period of time. That's what the statute of limitations is. No one is going to be able to testify with any degree of accuracy to refute that the employee's account. So it becomes very difficult to defend that claim. So our best practice recommendation would be, wherever possible, to avoid an automatic deduction. Ideally, you would like to have a very clear record of when the employee was working, when they were not, and pay for all of the time that the employee spends on the clock. Okay, so along the same lines, here's another ancillary issue that meal breaks sometimes cause. Hopefully everyone is aware of the requirement under the Section 195 of the New York labor law that you are required at both time of hire for employees and at any time that there's a change in their pay rates. You are required to provide employees with what's called a Wage Theft Prevention Act notice, a wage notice form that states on the form the employee's rate of pay. It provides information about their employer, the contact information for their employer, their overtime rate of pay, and crucially here, any deductions that the business is taking from those employees' pay. People hopefully are familiar with the idea that if you're utilizing a tip credit, if you're availing yourselves of the tip credit against the minimum wage for food service employees, for example, that typically this form is where you would provide notice of the fact that you are taking a tip credit. That notice is a prerequisite to being able to take the tip credit. So that is what these forms are most commonly recognized for. However, in addition to, as we'll see on the next slide, in addition to and there's the slide. So if you look at box 4 on this slide, where it says allowances taken, and this is a template form, by the way, that we just pulled off of the New York Department of Labor website. If you look at box 4, there are a number of codes in the box that the restaurant is required to complete if you are taking a credit. So tips would be the one if you're taking a tip credit. But if you are taking a meal credit, if you are deducting from employees' pay for the value of the meal, which we saw the applicable rates on a slide a few minutes ago, you are required to check this box and include the amount of the deduction. If you do not check the box and provide the amount of the deduction, it gives rise to a claim that you were not allowed to actually take the deduction. And that is something that an employee could theoretically bring a claim for, because what they would be arguing is that you failed to properly pay them at the minimum wage because they were paid at an amount below what the prevailing minimum wage is because we were taking credit for meals, but we didn't inform them or notify them of the fact that we were doing so, and therefore we weren't allowed to take the credit. So these forms are absolutely critical to ensure that you are not going to be, you're not going to get caught in a paperwork mistake that leads to a tremendous amount of potential exposure. So just as the case is for tips, these forms are also critical with respect to meals if you are going to take a meal deduction.
And just to quantify, potential damages on a wage notice can be up to $5,000 per employee. So to the extent you're not providing this to any employees, it would be, damages definitely add up.
So just very briefly, we mentioned the wage notice form, but also the meal deductions, to the extent that you're taking a meal credit, would also need to be listed on the wage statement, on the pay stubs that are provided to employees with every payment of wages, which in this industry has to be on a weekly basis. You would have to provide a record on the pay stub as to the amount that's being deducted for the meals. So an employee should be able to look at their pay stub and see what was deducted from their pay from that week for both tips and also for meals. Failure to provide that detail on the pay stub is also a potential violation of Section 195 of the New York labor law, and that also gives rise to a private right of action. So that is something that an employee could actually sue for in court. So as we mentioned at the beginning, although the basic requirement of providing a meal break is not something that someone can sue for in court, there are a number of related claims that flow from the meal break that absolutely are subject to private enforcement, this being one of them. So there are, we don't want anyone to come away from this thinking that, well, I can't get sued for not providing a meal break, so the risk is minimal. The risk is certainly there because failure to provide the meal break can lead to a number of related issues that are subject to private enforcement and also are commonly brought on a collective or class basis to the extent that employees are permitted to bring a claim even though their own individual damages may not be significant. If aggregated with everyone else who worked in a similar position over the statutory period of 6 years, it can become a very scary number very quickly.
And just to add to Adam's point, an employee might not be so savvy as to come up with these ideas by themselves, but if they go to an attorney, the attorney might ask, are you being provided a meal? Let me see that wage notice, or let me see your pay stub. And to the extent any of this information is omitted, it might be an issue for you. So we just want to keep it on everybody's radar.
And that's a great point. And keep in mind also that what I tell clients all the time in this industry and in others, but in this industry in particular, which is there's no stigma in this industry, unfortunately, for bringing a complaint or bringing a litigation, meaning that no one is worried about not being able to find another job by virtue of bringing a claim because the claims are just so common in this industry in particular. But if you end up, even if you have done everything right, and there's no ancillary claim flowing from a meal break violation, and the only thing that the employee is left with is not being provided a meal break, if they bring a claim, even if it's defensible, unfortunately, with our system, which is backwards in many ways, in my opinion, but with our system, you almost lose by virtue of a claim being filed, even if it's defensible and you can win the claim, because it is unfortunately one of those things that is so expensive to defend that it's often cheaper just to resolve it. So ideally, as difficult as it is, really where you want to be doing the work is to try to ensure compliance with these issues and ensuring that if you get a complaint from an employee internally about their meal breaks, take it seriously and ensure that it's looked into and try to come up with an acceptable solution for an employee, because ultimately the name of the game with all of these things is to try to resolve employee issues internally before the employee feels the need to go externally. Because if they go externally, even if we can ultimately prevail on the merits, we're still losing just by virtue of how expensive it is to do so. And I think with that, we left some time at the end here for questions. So Sarah, I don't know if we've received any questions, but we're happy to answer some
Yes.
over the next handful of minutes.
Lots of questions. And if you have questions for Adam and Cassandra, you can enter those into the Q&A box and we will try to get to them. Okay. So a good place to start, I guess, is the meal credits taken per shift or per pay period.
So you're taking the meal credit, it's per shift. So if someone works let's just say someone's working 5 dinner shifts in a week, they're shifts of, they're given an opportunity to work, to take an uninterrupted meal break. The idea is that you would be taking 5 credits because they were afforded 5 meal breaks during that week.
Does the employer have to provide a space for employees to go, like a dedicated break space for them to sit and eat, presumably?
So an employer is not required to have a space. I mentioned earlier, it might be, practically speaking, it might be advantageous to have a space away from their workspace. So this way it avoids them, getting tempted into doing any work or being pulled into any work when they're on a meal break. But under the statutes and the guidance, there's no requirement.
And if there's no, I would just, so obviously I agree with that, but I would also add that if there is no place in the restaurant, which sometimes is the case, for people to congregate and be able to eat without the risk of being pulled into work, although you don't have to permit people to leave the premises, if they want to, sometimes that's an easy way to ensure that the break is going to be interrupted, because if they leave the restaurant, there's certainly not going to be any risk of them performing work during their break.
Okay. Is there what constitutes as written consent to forego a break? Is there a specific form that already exists, and can an employee forego their break every shift if shift they work if they sign off on it?
So the answer is there is no form, there is no template Department of Labor form saying I consent to missing my meal break. And probably the reason for that is technically you're not, as Cass mentioned earlier, technically you're not permitted to waive your break on a habitual basis. So if someone, so it's the second portion of that question, Sarah, can someone waive their break on an everyday basis? Technically, the answer to that is no. Again, where I often come down on these issues is that we want to be in touch. It's really crucial for us to be openly communicating with our employees and listening to our employees when they come to us with concerns or gripes. Because if employees want to do, if we're getting feedback from employees or specific employees about wanting their meal break at a specific period or not, because of the fact that the underlying meal break claim is not one that's subject to private enforcement, really what we want to do is make sure that we've come up with a system that both complies with the, with providing a break. And even if we can't provide it at the exact specific time, we want to do something that we're sure the employee is comfortable with, because this is one of those areas where as I mentioned, the name of the game is trying to ensure a construct that works for the employee. So technically, no, there's no template form. It's something that you could come up with, but we would caution not to do it on an everyday basis, because that would clearly be a problem under the statute, and really just to utilize that when, for example, someone comes to you and says, hey, I didn't get my meal break today, I need to be paid for the time. We want to have some sort of documentation of that and some sort of system so that we can say, we had a process. If you had to work through your break, we paid you.
Cassandra, could you go back to the page where you listed the length of time, 6-hour shifts starting at 9 a.m.? Let's see.
I think that was the first slide. This one?
Yes. Sorry, there was a reason I wanted to do that. I just lost the question.
No problem.
Is it 6 hours or 6 hours or more?
It's 6 hours or more.
Okay. All right. That was a pretty specific question. Okay. Let's see. So just to be clear, the choices for meals are the operator can feed them, the employee can bring their own food, or they can leave the premises to eat.
Correct. The requirement for meals is really only with respect to the break, and if you are charging the employee for the meal. If you are charging the employee for the meal by taking a credit against their wages, you have to provide very specific food, and the restaurant obviously has to provide that food because that's what you're charging the employee for. But there is otherwise, aside from providing the break, there's no requirement as to what the employee needs to be provided. They can either go out, they can bring their own food. You have to allow them to bring their food there, or there can be a family meal situation in which you're charging the employee or not. A lot of the restaurants, I mean, I failed to mention two things that I think is worthwhile noting. A lot of restaurants choose to avoid any sort of issues associated with potential claims relating to the breaks and working during the breaks. A lot of restaurants choose to just pay employees during their meal breaks. So then if they only take 20 minutes or 18 minutes, it's not as big of a concern because they've been paid throughout the entire day anyway. And a lot of employees provide meals to employees. A lot of employers provide meals to employees without charging them for those meals for the same reason. Then we don't have to get into a discussion of whether there was a starch on the meal, on September 13th, provided with the meal on September 13th in 2019, because we didn't charge them.
So those rules come into play when you are taking the credits also, right?
So the credit, if you're charging the employee, then you have to meet with the very explicit requirements to be able to take the credit. If you're not taking the credit, then it's not a big deal. Employees can either choose to eat what we provide or they can bring their own food. We're not charging them for it. So the stakes are very different.
Okay. And if they are providing meals to employees, are they required to accommodate allergies as part of the ADA?
So that's a very good question. The answer to that question is, so there's nothing in the hospitality wage order that speaks to providing workarounds for employees with allergies. But as whoever asked the question notes, there are requirements under other state, federal, and city, if you happen to work in New York City law, that requires us to provide reasonable accommodations to employees. So the answer to that question is that if we are not going to provide folks with meals that account for their potential allergies or medical issues, or also religious restrictions, because there are sometimes religious restrictions and we have obligations to provide accommodations for those purposes too, then we should certainly not be charging people for those meals at a bare minimum. And I would argue that depending upon the circumstances, I think that there's an argument that the answer would be, yeah, if the fix is theoretically relatively easy, that we would be required to potentially provide that as a reasonable accommodation. Obviously, all accommodation questions are very fact specific, and it's a question as to the hardship to the business. But there is certainly a possibility that we would have an obligation depending upon the specific facts.
And just to add to that, a meal is considered, when I quoted back earlier, a meal is considered furnished for an employee who customarily eats that meal. If the employee can't eat the meal, then, the meal is not technically furnished by the employer. So just practically speaking, something to keep in mind.
Any special laws or regulations for minors in terms of this?
There are special laws and regulations with respect to minors in terms of the number of hours they can work, et cetera.
Yeah,
but as it relates specifically to meals, no.
Okay. Where do the rules for salaried and hourly managers fall in here? Are there any?
So the meal break laws are applicable to salaried employees as well. The difference is you don't have the risk profile is typically different because you're not going to be deducting for meals from a salaried employee's pay. They're going to be getting the same salary regardless of whether they're getting a meal or not. So all of the issues that we've talked about in terms of taking the credit, is the time paid or is it unpaid, clocking in and clocking out, all of that is simplified with respect to salaried employees because they're just getting they should be getting a consistent salary regardless of the number of hours that they work. So a lot of the risk associated with the meal breaks doesn't exist in that context like it does for hourly folks.
Okay, so two questions based on this scenario that the employer is paying for the breaks and also not taking the meal credits. So the first question is, do you have any recommendations for how to keep track that they actually had the meal and took the time if they aren't clocking out?
Sure. So if I understand the question, so we're paying them for the meal, so they're not clocking out because they're being paid.
Right.
And we just want to demonstrate compliance. So there's a number of different ways that restaurants do that. You could have a schedule that actually lists out the scheduled break time. So we could point to the schedule to demonstrate that we planned for breaks and we incorporated them into our regular day. Also, depending upon what POS system you use, you can do this either through the POS system or sometimes just with an old-fashioned paper form. But there are actually prompts sometimes that employees are required to complete when they're clocking out for the day, type of thing, where it says, were you able to take a meal break today? Yes, no, otherwise. So there are restaurants attempt to devise some sort of documentation to be able to demonstrate that we had a practice. And since, again, they're being paid, we're not worried about someone working without pay. We're really just looking to show from a broad strokes perspective that we had a policy or practice of providing the meal break. And so, that's a little bit of an easier lift than if we're trying to demonstrate that someone took 30 minutes and we haven't paid for it. So we need to demonstrate that they took an uninterrupted 30-minute break.
Okay, I have somebody asking me in here if their question will be answered, but they're listed as an anonymous attendee, so I don't know what the original question was. If you want to re-type it in, we can try to get to that one. And so then again, based on those same circumstances, so the breaks are being paid for and the employer's not taking the meal credit, they're asking if that alleviates these issues, as in requiring meal timeframes.
Yes.
If I'm understanding the question correctly, if we're paying for the meal break, if we're paying them all the way through the meal break, in terms of the timing, you're asking in terms of like the timing of it?
Yes, I think they're asking if they still have to follow these like 6 hours after 11 rules.
Okay, so my answer would be yes, we still need to comply with it, but to the extent it's not practical for your business, if you can't do the midpoint, that's fine. Or if someone's not working between 11 and 2, that's okay. We often see employers stagger break times. That's permissible, especially if you're paying through. I mean, you do have more flexibility. So I would say you should try to comply, but it's not going to come back to haunt you, especially if you're paying all the way through.
Yeah, I mean, what Cass is saying is 100%. The risk is significantly minimized if you are paying people for their breaks and you're not deducting for the meals, because now there's no dispute that the employee has been paid what they should have been paid. So the only thing we're talking about is the actual provision of the break, which again is there's no private enforcement of that. So oftentimes, restaurants in particular, because of the practicalities of the business, they push people's they require people to take breaks much more towards the beginning of the shift or much more towards the end of the shift. And since we're paying for the breaks and we're not deducting for the meals, the risk is relatively low, and it's not something that we typically see enforcement on. If people are given the opportunities for breaks, but they don't happen to be anywhere near the middle of the shift, they're very much towards the beginning or towards the end, typically something that we're relatively comfortable with.
Can you pay some employees during their breaks and others have unpaid breaks?
So that gets into questions that are really less wage related. Technically, under the wage and hour law, yes, but we would not recommend that unless you should not be making distinctions as a best practice between employees in the same role. Because if you are, it would get into a question of, well, someone might say, well, why am I not getting paid for my breaks, but this other server is? Maybe it's because of my age or my race or my religion, or fill in another blank of a protected group. It can lead to a differential treatment claim, so a discrimination claim. But if you have legitimate business reasons, or you're treating certain like front of house employees differently than back of house employees, and it's broken down for business reasons based on job description or job title, and not distinctions within the same job title, then that could be okay.
There are a few questions about waiving breaks, and is it safe to say that this is not something that you guys would recommend making a common practice, right? I mean, one-offs, maybe not a big deal, but if you're having somebody like that's consistently waiving their break, you already said not a good look for the Department of Labor.
Yeah, I mean, it's the same concept as, like, by law, you're not allowed, someone cannot waive their right to minimum wage. They can't waive their right to overtime. They can't waive their right to spread of hours. It's the same thing. Technically, you can't waive your right to a meal break. So the risk is a little bit less, because if they're paid, as I said, there's no private right of action with respect to meal break claim, but no, we would not recommend some sort of widespread waiver policy in which people are waiving their rights to a break because technically by law they're entitled to that.
Okay, if a kitchen employee starts their shift at 8, or I'm sorry, at 4 and works for 8 hours, they need to have taken a break, correct?
Correct.
Okay. All right. Okay, we'll do these questions for another like 4 minutes and then we will call it. What are the rules for employees working overnight? Is it still 30 minutes?
Yeah, so technically, if you look at the actual rules in the regulations, the meal break periods are actually longer than 30 minutes, but what the law says is that you can reduce them to 30 minutes so long as there's not a hardship to employees, and typically there would be no hardship to employees as long as they're allowed to bring their food to the work site and they have enough time to eat their meals. But there's no distinction between otherwise the hours in the day when someone's working in terms of the duration of the break. It needs to be, as long as they work a shift of at least 6 hours, they need to be provided with a 30-minute meal break, regardless of whether that's overnight, in the morning, across 2 days, etc.
Okay, we covered food restrictions. What about a wage deduction during a meal period? Does this need to be reflected on the wage notice form?
Go ahead,
So
Kat.
if you're taking a credit for the meal itself, then yes, it does need to be on the section 4 that Adam pointed out. But that's only if you're taking a credit for the actual meal itself and the meal meets the requirements that we went through in terms of the different components of the meal. That's enumerated on the screen right now. But to the extent you're not taking a credit and you are furnishing a meal, then it doesn't need to be provided on the notice.
That notice is only it's a wage note. It's supposed to educate the employee about how they are being paid. So if we're not deducting from their pay for the meal, nothing needs to be reflected on the form because it's not impacting the way that they are being paid.
Okay. So obviously there's some unpredictability in the hospitality industry. So if an employer has employees scheduled for 4 or 5 hour shifts, but the restaurant's busy and they end up working for over 6 hours, I guess what's the best way to handle that? Would the no lunch period be considered as an exception? Would we have no way of knowing they were going to end up being there 6+ hours? They're saying that they would have no way of knowing in advance they would end up being there for that long. Can we notate the issue within their time card to cover us and the employees?
So this is one of those areas where always keep in mind the priorities. The number one priority always is to ensure that employees were paid for all of their hours worked, for all of their minutes time worked. So long as we're paying them for the entire period, and there's a exception on a day where something happens, it's busier than expected, people had to work longer than we expected, such that they crossed the 6 hour threshold we didn't expect them to. As long as that's not a regular every day or every week type occurrence, I don't think it's a big concern because they've been paid properly. And our policy and practice is to give people with 6 hour shifts or more a meal break. This just happened to be an unusual occurrence. I don't think that's something that anyone should be overly worked up about. And presumably their shift times would be reflected in their schedules, they were scheduled for a shift length of less than 6 hours. And it just, for whatever reason, it didn't end up that way on that particular day.
If the employee works under 6 hours and takes a 15-minute paid break, should that still be tracked on their time card?
So
If
I would say that it doesn't necessarily need to be tracked on their time card so if it's 20 minutes or less, as Adam already explained, it needs to be paid. So if an employee is taking a break of 15 minutes or less, if we're paying it, it doesn't necessarily need to be marked down on their time card. There are reasons we might want to be tracking breaks to the extent, someone's abusing the system and taking 15-minute breaks regularly and not actually doing their work. We might want to know that, but it's not necessary as long as we're paying it.
Okay, and one last question. My apologies if we didn't get to everyone's questions today. Can we take a deduction Oh, no, I'm sorry. We take a deduction from employees for meals for each shift they work. Can an employee say they do not eat or drink and that they do not want the deduction taken? Do we have to document that meals were provided when taking a deduction from their pay?
So typically, as a best practice, we would recommend that restaurants at the time of hiring employees or periodically thereafter give employees the option as to whether they want to participate in the restaurant's meal program. If they do not want, like if they have significant dietary restrictions, for example, and they don't want the family meal, then they should be allowed to opt out of it, and we shouldn't be charging them for those meals. If people do not opt out, then they should be, then we have no obligation to provide opt-outs on, like they can't, we don't have any obligation to provide, like to let them see what family meal is going to be and then make a decision. So people have to make a decision as to whether they want to opt in or they want to opt out. If they opt in, they have to be afforded the opportunity to eat the meal, and the meal has to have the components that we've addressed. If they opt out, they should be permitted. If they don't want the meal, they should be permitted to opt out. So we don't have a situation where someone is claiming, I don't want family meal. I told them I never wanted family meal. I can't eat the food, and I'm charged every day for the meal despite that. That would be a problem.
Okay, Cassandra Ficano and Adam Gross, thank you so much for your time today. We always appreciate you sharing your expertise and knowledge with us. Thank you out there to everyone who joined us. As a reminder, the webinars are recorded, but they are available in our webinar archive if you are a New York State Restaurant Association member. If you're not a member, I'm happy to talk to you about that and give you some information. You can email us at info@niser.org and we will follow up. Hope everyone
Thank
has
you,
a good rest
everyone.
of your week, and we'll see you next time.
Take
Thank
care.
you.
Thank you.